Hello, everybody, and welcome to this panel for South by Southwest Online. I'm Lawrence Walters, and I'd like to welcome you to this panel. It's entitled Section 230, The Future of Internet Censorship. And this panel is going to take an in-depth look at a particular statute that has been the subject of some controversy of late, Section 230 of the Communications Decency Act. Now, rarely has a federal statute caused so much political debate and media scrutiny. So we felt it would be a good idea to conduct this panel and provide some background information about what the law is, why it's important, and outline some of the proposed changes and policy reasons for keeping Section 230 or amending it. And so we look forward to this discussion. I'm joined today by a panel of very educated and well-known Section 230 experts. With me here today, first is Elizabeth Nolan Brown. She's an associate editor of Reason Magazine, who has published countless articles on Section 230 and the broader topics of politics and civil liberties and technology and internet censorship. Elizabeth will give us her perspective as a journalist, a feminist, former sex worker, and a strong advocate for criminal justice reform and policy expert. So thank you for joining us, Elizabeth.
Thank you.
We also have with us today Emma Alonso, the director of the Free Expression Project, created by the Center for Democracy and Technology. Emma is a graduate of Yale Law School and works tirelessly to develop content moderation policies and best practices for online platforms, and advocates for user empowerment and tools for alternatives to government regulation of online speech. So it's great to have you here with us, Emma. And finally, we have Professor Eric Goldman, who is a full-time professor at the and co-director of the High-Tech Law Institute of Santa Clara University in California. Professor Goldman is one of the leading experts on all things Section 230, and we're happy that he could join us today. I'm Lawrence Walters of Walters Law Group. I'm going to be your moderator today, and I'm a First Amendment attorney based in Florida. And my practice has been pretty consumed by Section 230 issues for the last 10 years or so. So I appreciate the opportunity to lead the discussion, and we hope you find it interesting. So by way of kind of an introduction to the topic, Section 230 has been called the First Amendment of the Internet, the 26 words that created the Internet, but it's also been blamed as the root of all evil for online content and responsible for sex trafficking online, the cause of viewpoint censorship and political speech on social media platforms. And former President Trump wanted to reform Section 230, and President Biden wanted to revoke Section 230. So, what has these politicians in such an uproar? And Emma, I'd like to start with you, if possible. CDT has been involved in these policies related to online freedom and innovation, for many years. And so, I wondered if you could just briefly summarize, what is Section 230? What does it do?
Sure. Thanks, Larry, and welcome to everyone for joining this panel. And I think it is a really good idea to do a level set, because there is a lot of misinformation about Section 230 out there. But in the most basic terms, Section 230 shields online intermediaries from the legal risk that they would face in interacting with user-generated content, with our speech. It's important to think about the scale of online content. It's enormous, and to a large extent, intermediaries often don't really know what all is flowing over their services or available on their sites. Section 230 says that intermediaries shall not be treated as the publisher or speaker of third-party content, which means that the same kind of publisher liability that a newspaper or a bookstore might face does not apply to online intermediaries. Section 230 protects intermediaries from lawsuits for content that they host or decide to leave up or enable access to. And it also protects them from lawsuits over content that they decide to take down or remove or block on their services. And I say host, but Section 230 really applies to a whole broad range of intermediaries, including things like domain name providers, search engines, website hosting services, as well as things like social media apps or classified ad sites or consumer review sites. And it's important to recognize that there's this whole chain of intermediaries that we all depend on if we want to communicate online. Any link in that chain could be a choke point, could make the decision to block or remove our speech if they think they face legal risk for handling it. So that's why people talk about Section 230 as kind of First Amendment for the internet, or so essential to free expression online, because the broad liability shield that it provides really helps ensure that those intermediaries are kind of willing to handle all of the messy speech that people want to put on their services.
Thank you. That's a tremendous summary. I think that sets a good baseline for us to have our discussions. And so what I'd like to ask you, Professor Goldman, is why was Section 230 necessary? What was it like in before 1996 when online platforms existed but didn't have the benefit of this law?
Section 230 was enacted to address what I sometimes call the Moderators Dilemma. And there were two cases that came out before Section 230 was enacted that established pretty much two legal options for sites to do content moderation. One was that sites could undertake content moderation aggressively with the understanding that whatever mistakes they made, if they missed anything, they would accept full liability for that omission or that error. And so because of the legal risks of making a mistake, sites would invest quite heavily. But as Emma just mentioned, when you're dealing with high volume of content, it's inevitable that mistakes are going to get made at scale. And that, of course, scared some services from taking that approach. The other option was to try to pretend as if the sites were doing minimal content moderation, to do as little as possible, with the idea of destroying the argument that a plaintiff would make that the site knew or should have known that there was problematic content on their service. So by engaging as little as possible with the content that was coming from third parties, the site had the veneer of arguing that they didn't have the requisite knowledge or scienter to be liable for the content that was on their service. And Congress looked at that and said, that seems kind of weird. We really want services to engage in content moderation. It performs a socially valuable function to make sure that that problems online are being redressed by the internet services where they can. So the idea was to enable services to undertake that socially valuable work, but not face liability for the inevitable mistakes that might be made. And that's what eliminated the moderator's dilemma. And that's one of the reasons why Section 230 has worked so effectively by encouraging responsible moderation without holding liable the services that make mistakes that they couldn't avoid.
Yeah, so just following up on that, it's my understanding that Section 230 was part of a larger bill that prohibited all indecent content on the internet, and the Section 230 portion was kind of the trade-off, where online platforms would get an immunity for content posted by third parties, but at the same time, Congress was trying to prohibit any indecent content on the internet. So what happened with that other part?
So just to clarify, what happened is in 1995, there was a push to try to get internet services to regulate adult content. The main goal that Congress wanted was to get any of the pornographic material behind paywalls. They didn't try to eliminate all that content because they knew they couldn't on the First Amendment. They thought, let's just try and throw it behind paywalls. And so what happened is in the Senate, there was an effort to enact a law that would require this paywalled pornographic content. That was called the Communications Decency Act. In the House, two representatives, Senator Wyden and Representative Cox, said, we think there's a better way to go about this. If we could empower internet services to do the kind of work to look for and clean up indecent or otherwise problematic material, we'd rather have them do that. And so the law that became Section 230 was actually designed as an alternative to the Communications Decency Act. The Communications Decency Act passed the Senate, the Section 230 provisions passed the House, and then they were joined together in reconciliation when the differences were enacted. So the laws were never really meant to sit with each other. They were actually designed as alternatives to each other. And that's part of why it's a little bit confusing to talk about Section 230 as the Communications Decency Act. It was always meant to be the alternative. Now, the Communications Decency Act tried to avoid the obvious First Amendment problem of banning pornographic material online, but nevertheless, it was obviously unconstitutional, and it was enjoined within a week. And in about a year and a half later, the Supreme Court struck down the Communications Decency Act portion. So this interesting thing of two alternatives being developed, combined, one of the alternatives getting struck down, the other one then persisted. Is how we got Section 230 and not all the unwanted consequences of the Communications Decency Act.
So it sounds like we were left with a law that advanced online freedom and innovation, while the problematic law inhibiting First Amendment rights and free expression was struck down, and ultimately that resulted in the kind of Web 2.0 environment that we enjoy and know now. Section 230 has had a lot of critics, and Elizabeth, I'm going to come to you on this. We've seen politicians on both the left and the right having problems with Section 230, a lot of claims about the bad things that it does, claims that it allows for all kinds of illegal content to be posted on the internet with total impunity. Is that right? Or what is your thought on the criticisms of Section 230?
Yeah, I think the important thing for people to remember, because you're right that there's so many myths out there that it kind of behooves all sides of this debate, or at least, behooves the people who want to get rid of Section 230 or lessen it to push, is that it just lets websites get away with whatever they want to. It lets, tech companies do whatever sort of crimes they want and hide behind the fact that they're a tech company. It's important for people to know first that nothing in Section 230 prevents the application of federal criminal law. This only applies to civil lawsuits and state prosecutions. And maybe Eric and Emma can, explain more about that in a second. But it also, it doesn't apply if a website directly creates illegal content or engages in illegal activity. So if, I created a website and then I posted on there like, hey, I'm selling organs and sex abuse material, I wouldn't, just because I was a website operator, be allowed to go free because I was directly creating and promoting that content. And I think a lot of people don't understand that. But part of the reason it's really, hated by lawyers and attorneys general and states is because it does prevent them from going after these civil awards, and that's where all the money is. And so they're not able to, sue a website anytime anybody commits a crime or posts content that is later deemed to have facilitated an illegal transaction. It says, no, you hold the person who posted that content accountable, not the website who didn't even know about it existing. Or, so I think it prevents a lot of big payments and big settlements that they could be getting otherwise. And that's why it's become such a target over the years.
Absolutely. I think that's a great point. And, we also see complaints about the immunity that are provided to online platforms in connection with moderation. In other words, that, Facebook can take down content, or they can eliminate your account, and people are pushing back saying, hey, wait, you're discriminating against me based on my viewpoint or my political beliefs. Does Section 230 allow the platforms to take down, moderate content?
Yes, I mean, as Eric was just saying about that was one of the big goals. And I think that's what's so strange about this recent round of hatred of Section 230 is that the biggest myth these days probably is this idea that Section 230 requires companies or platforms or, internet companies to be neutral, ideologically neutral, politically neutral, and that if they don't, they lose that liability. But there's nothing in Section 230 that says that. In fact, it sort of, it actually lets them sort of discriminate based on whatever grounds. It says they can prevent content that is illegal and all these things or otherwise objectionable. So if I think that, all conservative content is objectionable or all liberal content is objectionable, and I'm a hosting content, I can decide not to allow that. It actually prevents having to force speech on these platforms and make them host speech that they don't want to.
So we're talking about private companies, and they can make those decisions as they please and decide what kind of content is appropriate for their platform. I mean, if you have a platform that deals with cat pictures, you wouldn't want a bunch of helicopters on there. So the same idea is that it allows the platforms to decide what kind of content is appropriate for their particular niche or platform.
Yes.
That's helpful. Emma, coming to you on, following up on what Section 230 does, there's been some arguments that the First Amendment already protects website operators or platform operators from liability for third-party content in the same way that maybe a bookstore would be protected from liability for the content of all the books it sells. Can't be sued for defamation if some author prints something in a book and the bookseller sells a copy of the book. That would be an absurd imposition of liability in connection with the First Amendment. Isn't it the same thing for online platforms? Why isn't the First Amendment enough? Why do we need Section 230 in addition?
Yeah, no, it's a good question. And I mean, you're exactly right that the First Amendment does provide strong constitutional protection to editorial decision making by private actors. And that would apply to, it does apply to online intermediaries, including website operators and everybody else kind of in the chain. But a really important aspect of Section 230 and how it protects speech online is the procedural protection that it provides to intermediaries. Section 230 makes it clear, kind of as a matter of statutory law, that a whole host of potential legal claims against an intermediary, potential lawsuits against them, are just not going to go anywhere. That means that early on in a case, an intermediary who is facing a lawsuit can say to the judge, you need to dismiss this case, even if all of the facts in this case were ruled against the intermediary's favor, there would still be no underlying legal claim, no way to say the law holds you responsible for what's going on here. This is called like getting out of the case at a motion to dismiss stage. And this is a really important kind of practical protection for intermediaries because it shields them from this sort of death by a thousand duck bites kind of issue of being drained by endless litigation fees. Even if a site were ultimately victorious in a case, even if they were proven to have not had the knowledge you would need to hold them ultimately legally responsible as a publisher of someone else's illegal content, or if it turned out that the content wasn't actually illegal, so there could be no liability for that intermediary, even if they were ultimately kind of vindicated in the courts, a long drawn out process of all of the lawyers' fees, the potential reputational damage to an intermediary being tied up in a lawsuit could be ruinous, especially to a smaller site that doesn't necessarily have a team of lawyers as some of its first 10 or 20 employees at a small startup. And the other kind of key thing to realize about this whole sort of getting out of lawsuits aspect of Section 230 is that it really changes the incentives for intermediaries hosting people's speech. Without the kind of the shield from litigation that Section 230 provides, if an intermediary, if a content host, gets has a claim filed against them and is told, you're going to be sued in court over this speech, the incentives are going to still be make that case go away as soon as possible. With Section 230 in place, that means you can file a motion to dismiss. You can ask the court to get rid of the suit. Without Section 230, the incentives are more like, okay, I need to settle this claim. I need to take down the speech, even if it might be lawful, even if there's nothing actually problematic for it. I need to make the lawsuit go away. And so it puts more of a pressure on the intermediary to say, I will make the problem related to this one post go away and take down that speech. That's a real threat to people being able to use services, to express, including things like controversial views or unpopular views. And if Section 230 were removed, other litigants would be very aware of this dynamic, the chance for a kind of heckler's veto, a use of lawsuits as a way to get an intermediary to silence someone else's speech would just skyrocket.
Yeah, so it sounds like Section 230 gives you a very quick pathway to get rid of a suit as opposed to litigating complex constitutional issues to potentially a trial or some kind of lengthy hearing. This provides a clear-cut path to victory and maybe even prevents a number of lawsuits from being filed in the first place. If the lawyer sits down and says, all right, let's sue Facebook, let's sue Twitter, and they do a little bit of reading and realize, okay, we're not going to get anywhere with this because Section 230 exists. Whereas if it was a kind of nuanced constitutional issue that could go either way, the lawyer might take the chance, say, let's give it a shot, file the lawsuit, and then drag the platform through lengthy litigation. And then your second point, I think, was very important, that in making these content moderation decisions, knowing that they have a clear pathway to victory allows the platform to tolerate more controversial speech and ultimately allows more free expression to occur on the internet, as opposed to what lawyers call the chilling effect of removing speech out of fear that the platform could be held liable under constitutional theory. Eric, just kind of getting into the weeds a second here. Section 230 has been called an immunity. Some have debated whether it's an affirmative defense. I know we're going to be talking about some of the reforms, but can you tell us why it's important for Section 230 to be considered an immunity from suit as opposed to, let's say, an affirmative defense to a claim?
I think there is some debate about whether Section 230 is an affirmative defense, but in the end, it rarely matters because courts will look to the complaint to see whether or not it's obvious that Section 230 would apply. And we see many cases where courts will say Section 230 is the burden of the defendant to prove. However, they can do so just by pointing to the things that the plaintiff said in its own complaint. But in any other respect, what we might call a safe harbor as opposed to immunity, when the burden is on the defendant to prove it, then they need to be able to introduce evidence showing why they did what they did, or showing that the plaintiff's complaint doesn't represent the facts. And that ensures that the case can get past the motion to dismiss. Once it gets past the motion to dismiss, then everything Emma discussed kicks in, discovery becomes expensive, management attention gets tied up, and the case just drags on. So the fact that Section 230 gets to the quick dismissals, whether it's called an immunity or an affirmative defense, however we get there, is really part of the secret sauce, what I call the hydraulics of Section 230. It's why it actually works as well as it does, and why it is different than the First Amendment, which doesn't require such procedural fast lanes.
That's really helpful. And, we've talked about the impact on existing platforms and benefits of Section 230 to getting rid of frivolous lawsuits or lawsuits based on user content and the ability to effectively moderate. My question to follow up to you, Professor Goldman, is what is the impact of having Section 230 on startup businesses or on businesses that haven't launched and are exploring the area of a user-generated content site?
Yeah, Section 230 applies to all internet services that publish third-party content. That ranges from the internet giants like Google and Facebook down to the person who running a hobby user-generated content service that's spending minimal time on it and making no money. And Section 230 applies to all of those equally. And the advantage of doing so is that it lowers the barriers to entry for the services that that are going to enter the market, not having to build the same kind of industrial grade and extremely expensive content moderation functionality that sites like Google and Facebook have already built for themselves. So by reducing the barrier to entry and by keeping those services from fearing the business ending liability that Emma talked about, it enables new services to constantly come on board all the time. And those new services then enter the market, keep all the other players honest through the competition, and ensures that the marketplace can still turn over. If you look at the leading internet services from 10 years ago or 15 years ago, you'll see that most of those services are no longer leading services, and they've been eclipsed or replaced by new services that have emerged over time. And we're not done with that dynamic. That's a constantly ongoing dynamic. That is the reason why that Google and Facebook aren't necessarily the final winners of this game, but a new service could emerge that would take their place or dislodge them. So Section 230 not only ensures that new entrants feel comfortable entering the market, but then also gives them reasons to be able to attract capital, knowing that the first X millions of dollars won't go to the lawyers to try to defend whether or not the market niche even exists. Those first dollars can go into actually building the product and catering to the audience.
So in summary, it sounds like Section 230 has the dual benefit of protecting free expression by existing platforms and protecting online innovation for those considering entering the marketplace without the tremendous burdens of litigation that Emma and you discussed so eloquently. Appreciate
Yeah,
that.
and just one more aspect of that, which is that it also allows internet services to look different from each other. So they're not all following the same editorial practices because they all are trying to optimize for minimal or minimizing legal risk. So we not only get the competition that comes from new entrants, we also get the competition from services figuring out different ways to cater to their audience and then developing different audiences and optimizing for them.
Thank you. Elizabeth, it's time to pick on you a little bit. I want to talk about some of the exceptions that have been passed and debated regarding Section 230, the first of which is FOSTA SESTA. And this is a law that was passed in 2018, which prohibits online platforms from engaging in activity that promotes or facilitates prostitution or contributes to sex trafficking. It creates an exception to Section 230 immunity for those purposes, for those activities. Can you tell me, the law was designed to protect protect sex workers in some way, to allow for prosecution of sex traffickers and to go after the traffickers more effectively. Can you tell us, was that law successful, and what was the impact of FOSTA SESTA?
No, there is no evidence that it has been successful. In the lead up to FOSTA passing, we heard so much about how it was absolutely necessary to pass this law in order to go after websites that were enabling sex trafficking or hiding sex traffickers. We needed to pass FOSTA so that we could save kids from sex trafficking. That's all we heard. And we especially heard that we needed it so we could save kids from being sex trafficked. It's never true, but just how true it is, how untrue it is, has become much more clear in the past few years. When it comes to Backpage was seized and its founders were arrested before Trump even signed FOSTA into law. So it was never needed to take down Backpage. There are a lot of problems with that prosecution to begin with, but the point is the feds were perfectly capable of doing this prosecution without passing FOSTA. We also heard that this, it was so urgent that we had to pass this, that even though victims groups said not to pass it as it was passed in its current form, and even though the DOJ even said, it's a little bit unconstitutional maybe in its current form, Congress still said, sorry, we don't have any time to work out those problems. We're gonna pass it right now. And they rushed it through because they said it was so urgent, they had no time to work out these potential issues. So fast forward, and more than 2 years go by after FOSTA passes, and they don't do a single prosecution. Finally, this past summer, so over 2 years have gone by since the law was passed that we so urgently needed it, allegedly. And the DOJ finally charged one person under FOSTA, a City X guide, which was a sort of Backpage or Craigslist-like site, but just for adult ads. And they took that down with FOSTA. But again, it was for facilitating prostitution, not sex trafficking. So again, this isn't even a prosecution that had to do with sex trafficking. And meanwhile, no states have brought lawsuits under FOSTA yet. There have only been 3 or 4 no states have done any prosecutions. There have only been 3 or 4 personal civil lawsuits that have been brought, and most of them have been either completely frivolous or just insane. The most recent one was brought by the conservative Christian values group formerly known as Morality in Media, which was big on fighting rap music and rock music and video games back in the 80s and 90s. They recently changed their name to the National Center on Sexual Exploitation. And a lot of people have just been like, oh, cool, yeah, they're a really normal group that's not, against all representations of sexuality and pop culture, even though they're still fighting to get Cosmo magazine removed from grocery stores. That's another one of their big planks. But they recently sued Twitter because it said Twitter was not quick enough in taking down a sexual video that a teen boy created of himself that was then posted on Twitter. And somehow they said this was A, sex trafficking, and B, Twitter's fault. And they're trying to sort of, retcon FOSTA to work in this case, even though, again, it doesn't really have anything to do with sex trafficking per se. I'm not saying that, we want this content to be allowed up at all, but this, it just doesn't really fit in the FOSTA framework. just so far, really the only things that we've seen actually happen because of FOSTA passing is that a whole lot of sites have cracked down on content that doesn't have anything to do with sex trafficking. Right after the law passed, Craigslist immediately took down its whole personals section, saying that that was too risky now. And we've just seen a ton of platforms crack down on any content relating to sex. And this is, we hear from sex workers all the time that they've been getting banned or suspended a lot more, just, for posting just any sort of semi-nude pictures that are a little bit sexual. And even if it doesn't have anything to do with commercial sex or sex work, just anything related to sexuality. There was a festival called Fetish Con that had its account suspended. So there's just been a lot more of social media and web services in general cracking down on anything related to sexual expression in the wake of it passing.
That's a very helpful summary. What about the purported benefits that were suggested prior to FOSTA passing? Has the law made it easier for law enforcement to find traffickers, and has it protected any sex workers?
No, I'd say no on that one either. In the first year after FOSTA passed, there were all these articles about law enforcement, local law enforcement talking about how actually it was a lot harder now to catch sex traffickers or to make sex trafficking cases if they did have a suspect or, in mind, because this is partly that has to do with FOSTA and partly having to do with the DOJ seizing Backpage. But, we had Backpage, which was this one very centralized place where a lot of people in sex work, legal sex work, adult services advertised. And we had, law enforcement was able to sort of monitor that. And when they did think something was wrong, Backpage and Craigslist and these other sites, they really cooperated. They proactively cooperated in notifying authorities if people tried to post pictures that, look too young. They would alert the National Center for Missing and Exploited Children. They would alert law enforcement. They also answered subpoenas from law enforcement about potential issues very quickly. They testified in court. They could provide things like the credit card numbers and the contact information for people who had been accused. So they really actually helped these, law enforcement make their cases. Now, since Backpage was taken down and since FOSTA passed, it's all just gone a lot more dispersed and a lot more underground. So it's, harder for law enforcement in general to keep tabs on the adult ad sphere, and then therefore to keep tabs on, any harm that might be taking place. And also a lot of the sites that are allowing any sort of adult content now, adult ads or, sex-related content now are encrypted, or they are based overseas and have their servers overseas. So they are not, able to provide this information to law enforcement, even if they wanted to sometimes, or they're just not cooperating with law enforcement. Or, because they worry that with FOSTA, it's going to increase their liability. And it's just really sort of broken down this system where actually, these companies that everyone portrayed as so bad were helping. And now there's none of that happening anymore.
Okay, well, it doesn't sound like it was a roaring success. How about the sex workers themselves? Are they in any better shape as a result of the passage of FOSTA?
I've not heard anyone say that, no. I mean, their big complaint has been, again, that a lot of the places where they would advertise, which helped make them safer because, it's a lot safer to be able to exchange emails or texts with a potential customer in advance and, have their information and things like that. Now they might be forced into more risky situations to meet clients. They might be forced back to third parties, what we would call pimps or traffickers, because they can't meet clients on their own without these spaces to post. And then they've also had, just their Twitter accounts and their Instagram accounts and stuff where they might be able to post and have that same sort of effect where they get to sort of screen people and where they get to tell each other about good and bad clients and things like that. Those opportunities have been taken away too. So if anything, it's, made them less safe.
Okay. Emma, turning to you from a policy perspective, a lot of the criticism of these platforms is based on the fact that they do not effectively moderate their content, that they're not finding the bad stuff and taking it down properly fast enough. But can you give us a sense of what some of the challenges are, the difficulties in terms of content moderation for an online platform?
Sure, yeah. So as I think we've all talked about so far on this panel, one of the big overriding challenges in anything to do with online content and content moderation is scale, is the fact that there are, on a very large site, a site like YouTube gets something like 400 hours of video uploaded every minute. But even on a smaller site, a site with 5 people on their trust and safety team that gets thousands of posts a day is not going to be able to review all of those posts before they go up. A person running their own site, and who's just an employee of one, who gets 100 posts in a day, is not going to be able to keep up. So no matter how large or small the website, this issue of scale for a user-generated content site is really significant. It means that you can't take a look at content before it goes live online. And the big question, thinking about illegal content, is then how do you find what of the hundreds or thousands or millions of posts on your service may have illegal content? Because the overwhelming majority of what people are putting on your service is probably perfectly lawful. It might be banal, it might be kind of pointless, but it's not, or it might be high art or, really thought provoking essays, but it's probably lawful. So you're looking essentially for needles in haystacks a lot of times, and you have to figure out, what are the approaches to identifying either illegal or just like harmful and abusive content, or content that's just not appropriate for your service. That will involve things like getting reports from users or law enforcement, or anybody who happens to see something on your site that they think might be illegal or is in violation of the service's terms and community guidelines. And then there's some services will try to proactively identify content. You can think of this as filtering often, using technology to try to scan the content that people are uploading or look through the content that's already been posted on the site to try to identify, can we detect content that includes nudity or sexual content? Can we detect content that might have slurs or defamatory or hateful speech? There's some utility in this kind of automated content analysis. A lot of different kinds of sites use automation in different ways to help with the process of moderation, but it is by no means a magic bullet. We can't just sort of throw AI at a social media site and find all the hate speech and be done with it. So the process of kind of detecting content is usually typically a kind of best efforts scenario. You might have a system that's pretty good at finding certain kinds of content, like content depicting nudity, but it's not necessarily going to tell you, for example, is this related to a sex trafficking ad, or is this artistic nudity or educational nudity, or some other totally appropriate kind of content. So it's go ahead.
Please finish.
So it's a part of this kind of question of how do you manage the content on a service really ends up creating some challenges if you have a legal structure that's looking at kind of liability for specific instances of content. Finding that needle in the haystack can be really difficult, but trying to kind of get a handle on the content in general, or have processes in place to respond when people report abusive content for you, is really important.
Well, that's really helpful to outline the challenges that come along with content moderation. Apparently, there's just not a simple algorithm that everybody can use and get rid of all the bad speech. So these are eternal challenges that all online platform operators face. But I want to go back to FOSTA for a second. And Professor Goldman, can you tell me, looking at what FOSTA did and kind of the fallout, did we learn anything from a policy perspective from FOSTA and carving out immunity to Section 230 as a legislative tool?
I think we did. The question is whether we'll listen to the message that we're hearing. And I thought Elizabeth did a great job of showing that the law didn't benefit victims of sex trafficking and may have made things worse. It had huge negative impacts on the sex worker community, and it shrunk the internet. And excised pieces of the internet, including things that were constitutionally protected, as a prophylactic to try and avoid the potential risk of liability. So the thing that's so heartbreaking about that is that Congress was told all of that during the FOSTA proceedings. A number of us had the opportunity to tell Congress about what would happen, and Congress just didn't care about whether its policy reform would actually accomplish its goals. So here we are now. We see that that FOSTA did not accomplish its goals and may have actively harmed the victim communities that it was trying to serve. And so that one would think that would counsel against additional carve-outs to Section 230 based on victim advocacy, that really tire kicking what's going to happen to that victim community and other communities if Section 230 is carved out to create a new workaround. And that's just not the conversation that Congress seems willing to have. So I think the lessons in FOSTA are clear, but since Congress ignored it before and after FOSTA, it makes me really scared about the next round of Section 230 reform.
Indeed. Just going back to you for a second, Emma, on the Section 230 reforms, you see a number of different reasons put forth by folks who are looking to carve out or eliminate Section 230 immunity to address various social ills ranging from child pornography to terrorism, et cetera. What are you seeing at CDT as the reasons why people are asking for Section 230 reform now?
Yeah, it's a good question because there are a lot of different reasons, some of which are totally contradictory to each other. So there are proposals kind of framed in the FOSTA SESTA sort of style, carve out of Section 230 protection for specific kinds of content that's already illegal. So child sexual abuse material is a big one. The Earn It Act bill introduced in the last session of Congress was really focused around this question of liability for sites that kind of should expect that they have CSAM on them. There were a lot of problems with the Earn It Act, but that bill may come into play this Congress as well. Then there's a kind of thread of discussion around Section 230 that is looking at things like kind of transparency and due process around content moderation and how companies kind of create their policies and enforce their policies against user speech. These bills can get kind of contradictory as well, or it's not always clear kind of what the goal is of them. Sometimes you see a really prescriptive effort to say, what should be in the content policy of a given site, or to say that they may not have policies about certain kinds of speech. This gets into some of the concerns that certain kinds of speech, or particularly conservative political speech, is getting overly censored on social media. There's not really any evidence that that's happening, but it is a big motivator for some of the bills. But there are also bills that are looking at kind of more neutrally at whatever your policies are, you need to enforce them consistently, and you need to give people the ability to appeal takedowns and provide transparency reports. And there's potentially some useful ideas in those kinds of approaches, but it also does start creating this dynamic of if a website faces liability for failing to enforce its own content policy consistently, that is a pressure towards the site to have a pretty minimal policy. The fewer things you promise to users you will take action against or take down, the more shielded from potential liability you will be. That's potentially the wrong direction to go if what we're looking for is, for websites to take stronger action against hateful speech or harassing speech. So, there are definitely some complications in that set of ideas. There's also a lot of focus on the role of ranking and recommendation algorithms. So this often brings in a lot of concerns about disinformation or extremism, the sense that the content that different services promote and put in front of people, there should be some liability for the service itself for making that kind of choice to put certain content in front of people. Those bills also get very complicated very quickly because, when we're thinking about online content, again, scale is the issue. We all are using different algorithms and technical processes to sort of sift through content, to find information that's actually useful and relevant to us. So we absolutely need algorithmic mediation of online content. That's how search engines work. That's how, just finding information that's useful to you, even on a social media site, is going to work. So if there are strong disincentives in the law against people using ranking and recommendation algorithms, it could make access to information online a lot less useful. And then there's also some discussions, including recently, around the role of civil rights law and how that may apply online, including to things like online advertising. So there's been a long-running discussion about things like housing, credit, and employment ads, which under our civil rights laws in the offline context, it's very clear, disparate impact and disparate targeting of those kinds of advertisements is a problem. If you're, only posting a job ad and directing it towards white people or towards men, that's going to raise discrimination issues. So there's an interesting conversation going on right now of whether and how those laws work in the online advertising context, which can be a really complicated ecosystem with lots of different intermediaries. So I'd expect to see a lot of focus on those issues as well coming up this Congress.
That's very helpful. And how about you, Elizabeth, from a journalist perspective, what are you seeing in terms of these calls for Section 230 reform and some of the misconceptions that are being put out as to what the benefits of reform, what reform could actually accomplish, that kind of thing?
Yeah, I mean, just to speak to Emma's point real quick about all the different kinds of changes to Section 230 or all the different justifications for them that we're seeing, I think that really gets at how bankrupt the ideology behind FOSTA and the back page prosecution, all this stuff was to begin with. Stopping sex trafficking was an easy way to do a sort of test case for whether people would tolerate changes to Section 230 and carve outs to it. No one wanted to vote against the children, but I don't think that was ever really the point. I mean, there were obviously some activists who really believed in that what they were doing was the right thing, we're doing it. But at a political level, I believe, Section 230 at large has been the point. Politicians don't like it because it doesn't let them, have a lot of control over online speech. They can't sue companies out of existence or use the threat of suing them out of existence and stuff to sort of have more control over what people say online. And they've been wanting to get rid of Section 230 for a while. And FOSTA was just sort of, sex trafficking was just sort of the first thing that let them. And the fact that we see now, like all these things, and like Emma said, also contradictory things. You have Republicans saying, we need Section 230 reform because it'll allow more speech to flourish online and more conservative speech and more of these types of things that liberals now think is hate speech. But we need Section 230 reform so we can say these things. And then you have liberals saying, no, we need Section 230 reform so we can stop them from saying all those things. Like, they're not going to be able to say any of that anymore if we have our way. And it's just like, clearly those two things cannot happen simultaneously. And the fact that they're both saying we need the same thing to accomplish these two totally divergent goals, again, I think should make people just really question what the actual goal is here. And it is not what either, politicians from either major party are saying it is.
Politicians are disingenuous.
I know.
I'm shocked, simply shocked. Eric, I want to get to you. I want to make sure that we talk about some of the reforms that are actually on the table, and in particular, the SafeTech Act, which was recently introduced by some Democrats. And can you give me your thoughts on the act itself, whether it's a good, bad idea, and as Congress is looking at some of these reforms, what should they be guided by?
The SafeTech Act is a pretty complicated bill because it has over 10 different reforms to Section 230. 6 of those fit into the bucket of new carve-outs for specific types of content or for particular types of claims. So they're kind of doubling down on the FOSTA type approach, as we already discussed, with all of its downsides. A couple other claims get at the flows of money, and the general gist is that SafeTech would eliminate Section 230 for anything that the service gets paid to make accessible, or for any content that the service pays to acquire. So the former example might be something like advertising, and the latter example might be something like any site that does a rev share with its users. But the drafting is written so broadly that it really goes straight to the heart of the entire UGC ecosystem and how money flows in that. And the changes to that particular category really make it almost impossible for most services to survive and keep Section 230. But if they get rid of Section 230, they probably can't survive anyway. And I'm not an expert in logic. I think that's a Morton's fork, though. That the outcome's going to be the same either way. It remains to be seen if the SafeTech Act is one of the bills that other members of Congress get behind. As Elizabeth mentioned, it's not likely to garner Republican support because of the fact that it actually would motivate greater content interventions, and that's not what the Republicans are advocating for. Though it does raise the risk that we might see some kind of weird backroom coalitions form, where maybe these senators can strike a deal with some of the Republican senators, give them something else that they want, put it all together in a Frankenstein bill, and then we're in very dangerous times in terms of our future internet. I did write an article earlier this year that was an open letter to President Biden. That's the way the request was styled to me, but it's really a cautionary tale for Congress, where I recommended 4 things that Congress should be considering as it takes a look at Section 230. The first is to set the accurate factual baseline, that as a baseline, humans are awful to each other online and off. It's not to excuse it, but it is a reality that we have to confront, that people do terrible things to each other offline. And we can't expect that the online world will eliminate all those terrible things that people do to each other. So we have to understand that there will be terrible things online. And we've really seen regulatory pressure saying, no, we don't want anything terrible online. To which we say, do you understand how humans interact with each other? That's not possible. The second is establish an accurate legal baseline. And that gets to the points that we were discussing earlier with Emma about how the First Amendment and Section 230 sit next to each other and why Section 230 is such a helpful complement or enhancer of the First Amendment. The third thing is to make evidence-based policymaking. That goes to the conversation that we've had with Elizabeth about the fact that FOSTA is an example where Congress didn't look at the evidence that was available to it and made a terrible decision with the logical, predictable consequence. And the last thing that I hope that Congress will do is recognize how much damage we've done as a country to our standing internationally as a leader in of free speech. The Trump administration took so many efforts to try to suppress free speech that we really lost a lot of international credibility on that front. And so Section 230 is an example of something where if we take that, if we reduce that, it's one of the things that's really helped us distinguish us from the rest of the world as a leader in free speech. We actually send a message to all the rest of the world. If you want to go and regulate the internet, if you want to go censor internet content, have at it. We're certainly going to do the same in our country. So I hope that Congress will really think about what it does as a signal to the rest of the world and to the signal to the entire internet about how we feel about free speech.
Those points are tremendously important. I appreciate you sharing them with us. And incredibly, we have filled our panel time. So I want to thank our panelists. Thank you, Elizabeth and Emma and Eric, for being here today and preparing and sharing your knowledge and your expertise. Thank you to South by Southwest Online for publishing this panel. And we appreciate the attention of all the audience members, anybody who's watching. Thanks again. We'll see you.